Today, we will be discussing the arbitration landscape in India, developments in the recent past, and the future to which it is headed. Now, why arbitration? I think because arbitration is one of the most sought after alternate dispute resolution mechanism the world over. And I guess rightly so, because of the flexibility and the finality it offers. Flexibility in terms of appointment of arbitrator, choice of arbitral tribunal, choice of procedure, and even the seat of arbitration. And finality, well, in terms of judicial recognition and modes of execution. The arbitration scenario in India has undergone good development in the last few years, more so during the pandemic. This development, however, comes not through legislative enactments but through judicial activism. The various high courts of the country, along with the Supreme Court of India, have passed several orders in the last year and a half which have touched upon the nature of disputes that are arbitrable. They have touched upon procedural incongruities, they have touched upon matters of international commercial arbitration, and have been generally in terms of support orders to arbitral proceedings, thereby making a push for further arbitrations in future. What are some of these orders that have touched upon the aspect of arbitrability of disputes? In India, until recent past, there was much discussion and deliberation whether trademark infringement disputes may be referred for arbitration. The Indian judiciary has recently clarified that where the use of trademark has been licensed by way of a license agreement and the trademark is being made use of in a way either contrary to the terms of the agreement or in a way not provided for under the agreement, in such circumstances the dispute may be referred to arbitration, provided however that there is an arbitration clause in the license agreement or an independent arbitration agreement which has been executed between the parties. Another such aspect which has now been clarified is qua landlord-tenant disputes. The Indian judiciary has also clarified that in case of landlord-tenant disputes which are not specifically covered by any special enactment, any special rent control enactment, those disputes may be referred again to arbitration provided there is again an arbitration clause or an independent arbitration agreement between the parties. The most significant development, however, is with respect to arbitrability of fraud-related disputes. Now, the court has settled the proposition of law on this aspect as well, which is to say that where the allegations of fraud emanate out of a contractual arrangement, such that the fraud pertains only to the contracting parties and has no bearing upon the people at large, then only such limited cases or allegations of fraud may be adjudicated by reference to an arbitration agreement. Let us now discuss some of the developments on the procedural end. On the procedural side, the developments relate to the Limitation Act, to the Insolvency and Bankruptcy Code, and to the procedure inherent in the Arbitration and Conciliation Act. In respect of the Limitation Act, the Indian judiciary has now clarified that the limitation for filing an application seeking appointment of an arbitrator or an arbitral tribunal is 30 days from the date on which the arbitration is first sought to be invoked, and not from the date when the request for arbitration is rejected by the opposite party. Another more significant procedural development is with respect to the Insolvency and Bankruptcy Code, where the courts have now upheld and settled the law that till the time a petition under the Insolvency and Bankruptcy Code is duly admitted by NCLT, till such time the dispute between the parties may be referred for arbitration. This comes with an explanation that till the time a petition under the Insolvency and Bankruptcy Code is so admitted, the dispute continues to be a dispute in personam. The final and most significant development with respect to procedural incongruities come with respect to the right to challenge an arbitral award. One of the grounds for challenging an arbitration award is if the party has been denied an opportunity of representing its case. Now, the courts have clarified that where the right of a party to file necessary pleadings or make necessary representations for the tribunal is closed due to the party's own fault for lack of, maybe for not adhering to the suggested timelines, then in such cases, the closure of right will not tantamount to denial of a right of being heard, and as such will not be a further a ground for challenging of the award. Other more significant changes in respect to arbitration law comes in the form of pro-arbitration rulings. These rulings touch upon the supervisory jurisdiction of the court, where the courts have held that though it enjoys supervisory jurisdiction over arbitration proceedings, it will likely not interfere in such proceedings till such time as bad faith in the proceedings is manifest and apparent on the face of it. They also touch upon aspects of interim reliefs, wherein it has been observed that till such time as an arbitration tribunal is constituted or an arbitrator is appointed, the parties may approach the necessary courts seeking interim relief. This has come with a view so that the parties' rights are not frustrated due to the time it takes for composition of the arbitration tribunal. Thirdly, touching upon the aspect of interpretation of agreements, the courts have held that where the arbitration agreement or a part of an arbitration clause is inoperative, the inoperative portion should be severed and the operative portion of the agreement should be given effect to, thereby making a more certain push in the direction of future arbitrations in the country. In reference to international commercial arbitration, the courts have settled two very important aspects of law. The first pertains to the interpretation of the term international commercial arbitration under the Arbitration and Conciliation Act. The courts have interpreted and upheld that any arbitration where a foreign national, be it an individual, a company, or even the foreign government is a party, will now be interpreted to mean and include an international commercial arbitration. Under the second development, the court has held that where any payment is made in an international commercial arbitration, no TDS shall be deducted from the said payment under the Indian laws. The courts have further clarified that where any payment is supposed to be made in foreign currency, the date for determination of foreign exchange rate should be the date on which the award attains finality. In my opinion, these recent rulings reflect the Indian judiciary's intent to promote arbitration as an effective mode of dispute resolution and adjudication. It is in this spirit that these rulings have come, paving the way for future arbitration and settling the legal regime surrounding it.